Liabilities of personal representatives. 1. Liability for waste conversion. A personal representative who commits waste or converts to his own use any part of the estate of the deceased shall, to the extent of the available asset of the defaulter, be liable for such waste and conversion. Ibrahim and Osunde. It is wrong in law for an administrator of an estate to assimilate the property as his own. 2. To pay all the taxes that may have been imposed on the estate that is administering. 3. Liability to creditors or beneficiaries. Where beneficiaries are dissatisfied with the management of the estate by the personal representatives, they may institute an action against the personal representatives. 4. Liability as an executor disuntoward. A person who intermeddles with the estate of the deceased to be in his own wrong as executor disuntoward. 5. Liability for co-representation. The representation of personal representatives of the estate is joint. They must take liability for their actions. Ibrahim and Ojomo, 2004, All Federation Week Law Report, Part 203, at page 2109. 6. To be cited to take up probate. Where a person appointed as personal representative of an estate fails to apply for a grant of probate, he is liable to be cited by the court to take up the probate or to renounce the probate. Discharge of liability for personal representatives. 1. Express provision in the will. Where the will has expressly provided that the personal representative shall not be liable to the estate of a deceased for any act or omission. 2. Relief obtained from beneficiary or creditors affected. 3. Relief from the court. 4. Plea of limitation. Accounts to be kept by a personal representative are: 1. An inventory. This is a record of all the property and assets of the estate. 2. An account of the administration. 3. The vouchers in the hands of the executor or administrator. 4. A verifying affidavit. The executor is to justify every expenditure and expenses made by him and make a report of stewardship of properties and accounts that were controlled and administered by him. It is important to note that the personal representative is supposed to file these accounts in court every 6 months from the date of the grant or appointment until completion of the administration. Order 55/46 of one of the High Court Civil Procedural Rules of Lagos State. Where there is a discrepancy or unvouched entries, the court may summon him to appear and remedy the defect. Other circumstances where a personal representative is required to render account are: 1. Where there is a complaint of maladministration of the estate against the executor. 2. Where before completion of administration there is an application for the removal of the executor. 3. Where a personal representative who has been given probate applies to court for leave to surrender the estate vested in him to the Administrator General. Section 32 sub 1 of the Administration of Estates Law of Lagos State. 4. Where there is a completion of administration of the estate and the personal representative is to submit a final account to the court. 5. Where he has made any unauthorized payment. Very important, a personal representative cannot make any profit from administering the estate. To this effect, he has to account for any such profit made. It is also important to note that a personal representative is not allowed to purchase or acquire any property of the estate of the deceased. Winding up of estates and discharge of personal representatives. Winding up of the estate of the deceased person takes place upon a conclusion of the administration of the estate under the terms of the probate or letters of administration. Once the estate is completely administered, the personal representative shall file a final account to the court. Where the court is satisfied with the account, it may be discharged from the office of the personal representative. However, such a discharge does not make him immune from liability or suit by creditors and beneficiaries. Ethical issues. 1. Duty to faithfully administer the estate in a situation where the solicitor is appointed as an executor. 2. Duty not to charge remuneration on the estate if there is no charging clause in the will. 3. Duty of competence, Rule 15 of the Rules of Professional Conduct. 4. Duty to avoid conflict of interest, Rule 17 of the Rules of Professional Conduct. 5. A solicitor must ensure that he does not double as a beneficiary and executor of a will. Taxation. Taxes are compulsory charges by the government on the income of an individual, corporation, or trustee, as well as on the value of an estate or gift. It is a compulsory levy imposed by a competent authority or organ of government for public purposes. The primary function and objective of tax is to generate revenue to meet the government's expenditure. Generally, taxes are levied directly or indirectly. Direct taxation occurs where persons are taxed to pay for no particular services or goods delivered, but simply for maintenance of government and its services. Indirect taxation occurs where persons are charged for services rendered to them, transactions, or for other activities. Taxes collected by the federal government includes 1. Companies income tax, 2. Withholding tax on companies, usually for residents of the Federal Capital Territory Abuja and non-resident individuals, 3. Petroleum profit tax, 4. Education tax, 5. Capital gains tax, 6. Stamp duties, and 7. Personal income tax. Taxes collected by state governments include 1. Personal income tax, pay as you earn and direct self-assessment, 2. Withholding tax for individuals only, 3. Capital gains tax for individuals only, 4. Stamp duties on instruments executed by individuals, 5. Road tax, 6. Pools, betting, lotteries, gaming and casino for individuals, 7. Business premises registration fees, 8. Development levies on individuals only, 9. Registration fees for naming of streets in a state capital, 10. Markets where state finances are involved, 11. Right of occupancy fees over lands owned by the state in urban areas of the state. Applicable laws are 1. Land Use Act, 2. Capital Gains Tax Act, 3. Personal Income Tax Act, 4. Stamp Duties Act, 5. Land Instrument Registration Law, 6. Value Added Tax Act, and 7. Companies Income Tax Act. Taxable transactions. They include 1. Sale of land, 2. Mortgage, and 3. Lease. Overview of taxes payable in property transactions. Capital gains tax. These are levies charged on the gains accruing from the disposal of assets as provided for under the Capital Gains Tax Act. Capital gains tax shall be chargeable on the total amount of chargeable gains accruing to any person in a year of assessment after making such deductions as is allowed under the Act, Section 2 sub 1 of the Capital Gains Tax Act. These gains are those resulting from increases in the market value of assets to a person who does not regularly offer them for sale and in whose hands they do not constitute stock in trade. The tax is on the gain of the disposed property, and this implies that if no gain is made, the tax cannot be charged. The chargeable rate for capital gains tax is 10% before computing the gains. Allowable incomes are deducted. Section 13 of the Capital Gains Tax Act. Allowable income. This is income that is wholly or exclusively and necessarily incurred for the acquisition of the assets together with the incidental costs. It is regarded as allowable income because it is reckoned with in the computation of the gain. Allowable incomes include 1. Amount paid for the acquisition of the property, 2. Incidental cost for acquisition, 3. Amount incurred in enhancing the value of the property, 4. Amount spent on the establishment, preservation or defending of the title or right over the asset, 5. Cost incidental to the disposal of the assets such as cost of advertising, cost of valuation of assets, 6. Fees, commission or remuneration paid to professionals, e.g. surveyors, agents and valuers. In an attempt to calculate allowable income, there are exceptions. A. Cost of disputing the taxable portion, e.g. engaging the services of a solicitor to institute an action. B. Direct labor put into the improvement of the property shall not be allowed, e.g. Mr. A wants to paint the house himself through his family members. He will not be allowed to deduct payment for the direct labor. Upon redemption of the mortgage and reconveying property to the mortgagor, it does not amount to disposal of assets. This is because mortgage transactions are not sale transactions. C. Devolution of properties to beneficiaries by a personal representative does not amount to disposal of interest. capital gains tax will be paid. It is important to note that when the executor sells the property to third party in order to raise money, that is taxable. Persons and organizations exempted from capital gains tax in respect of properties disposed by them are 1. Religious, charitable, or educational institutions of a public character. 2. Statutory or registered friendly societies. 3. Cooperative societies registered under the Cooperative Society Law of a state. 4. Trade unions registered under Trade Union Act. 5. Gains accruing to the local government. 6. Gains accruing to any company and authority established by law to purchase and export commodities from Nigeria. 7. Disposition by way of gifts. Quick glance note is powered by Rooms and Luxury, your choice real estate agency in Lagos, Nigeria. Address is number 7 Tower Conic Close of Idemai Crescent, Igbefon, Lekki, Lagos, Nigeria. Tell WhatsApp 08142775425 09156911367 and send your emails to ronumsandluxury@gmail.com, Instagram Ronums and Luxury, Facebook Ronums and Luxury. You can call them for all your real estate questions. For sponsorship and advert placements, please contact 09125921620 or send an email to resistandpartners.chambers@gmail.com.